It is the first day of trial in a case where the NDC's presidential candidate in the 2020 presidential elections, John Dramani Mahama, is challenging the declaration of President Akufo-Addo as winner of the 2020 presidential election. Our election petition update here on Joy News is in association with Petrosol. Clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof experts. And Kwa Mixture, the immune booster for your general well-being. So we've seen Johnson Asiedu Nketia, a witness, take the stand at the Supreme Court, except that we haven't heard him say a word apart from being sworn, taking the oath. What we've heard really and what we've been witnessing are some objections being raised by lawyer for one of the respondents, Nana Adedankwa Akufo-Addo Kotoampao there. Our court correspondent, Joseph Akabley, joins us with more. Joseph, if you can hear me, there is a bit of confusion. I don't know if it's confusion, but maybe we can clear that. We've already had that case management, that pre-trial conference. And so this was supposed to be the trial, the beginning of the case proper. Joseph, can you hear me?
So the point we need to make is the fact that at the time that the case management... Yes, I can hear you, Mavi.
Joseph, go ahead, please.
So at the time that the case management conference took place, and if you recall, at that time, witness statements had not been filed, and so that is the point that is worth making. And at that point, the court dealt with the issues of settling the 5 issues that are to be trialed, and then afterwards give further directions relating to the witness statement that are to be filed. What is happening today, this morning so far, is that Mr. Asiedu Nketia entered the box. Per the directive that came from the Chief Justice this morning, he was supposed to identify the statements. After being sworn in, he was supposed to identify the statement that he had signed. And once he identifies it, cross-examination takes place. Now, it was after identifying the statement that Mr. Kotoampao, who is lawyer for President Akufo-Addo, did indicate to the court that they have objections with regards to some portions of the statement that they want taken out. Their position on the matter is that once he's identified the statement and indicates to the court that he intends to rely on the statement, it means that it is taken into evidence. And it becomes evidence that the lawyers for the respondents would have to now lead evidence to rebut. And so they don't want it to get into evidence in the first place by saying that, look, there are portions of it that we want taken out before even it is adopted and put in terms of the court. The judge, that is Chief Justice Kwesi Enyinye, did indicate that it's actually already before the court because it has been filed. But then they should wait. Once he identifies the statement, then that objection will be raised. And so that is what is happening. And so the point about whether or not it could have taken place during the case management, we know for a fact that at the time the case management conference took place, these statements had not been filed. And so maybe as some lawyers have made a point that in the past, all those matters would have been dealt with and have been corrected before the trial itself takes place. Those are other issues that we can all look at and talk about going forward as to how such matters should be handled. And so that is the issue with regards to the witness statement and the concerns that were raised by Mr. Kotoampao in response to the question that you asked, Mavi.
I want us to go through the paragraphs that the respondents, the 2 respondents, I must say, because they agree on the objections. We will go through those paragraphs again, but just explain, Akabley, the justification why these paragraphs must be maintained in the witness statement, what Chachi Chikata has been saying.
And so the point that Mr. Chikata has been making, he made reference to a rule, and the specific rule that he made reference to is Rule 7 of Order 11. And he makes the point that that rule makes it clear that every pleading shall contain statements in a summary form of material facts, and the statement must be brief. And so his argument is to the effect that, look, we filed a petition. In the petition, we were required to make certain statements in a brief manner. And those statements, evidence will be provided in the form of witness statements to support the pleadings. The argument that his colleagues on the other side, Mr. Kutuampao and co had made, was to the effect that, look, your petition does not make some of these allegations. It does not even make it at all. But in your witness statement, you are making reference to those allegations. And the response Mr. Chikata makes is by reading the rule that I just read, is to say that it's supposed to be a summary. The pleadings are supposed to be a summary, and so we simply summarize the issues that we wanted to raise, and we have eventually decided to now raise them in a manner that we have raised, in the form of the evidence that we have brought to the court. And so that was the point that he was making with regards to why he believes all aspects of the witness statements should remain intact.
And this is a 39-page document that we're talking about. And out of that, about 10 paragraphs have been identified. There are some of the paragraphs that Kutuampao argues he's not asking that they strike the entire paragraph out, but portions of sentences in that. But in some of the other paragraphs, he's asking that they strike that entirely out. Talk us through a bit, if you may.
Yes, Mama V. So I'm going to walk you through the specific paragraphs that have become the issue of concern this morning. So the first paragraph that he made reference to is paragraph 21. That was the first paragraph that he raised issues with. And the point he made about paragraph 21 was to the effect that it is not pleaded in the petition. And I will take you to paragraph 21 of Mr. Asiedu Nketia's witness statement. And it says at that particular paragraph that, and I read from it, it says, following that, the results being published by first respondent on its website, www.ec.gov.gh, became moving targets. First respondent subsequently deleted the changing figures from its website. And so this is the paragraph 21 that Mr. Kutuampao makes reference to, that nowhere in the petition is reference made to these changing figures on the EC's website. He then goes on to talk about paragraph 6 and paragraph 7. Now, paragraph 6 in Mr. Asiedu Nketia's statement says, petitioner has caused to be filed a request to admit facts directed at first respondent. I am informed by petitioner's lawyers that as at the time I am signing this witness statement, first respondent has not responded to the request. I am advised by counsel and verily believes him that a response of first respondent or lack thereof to the request to admit facts is likely to require further witness statement from me. Paragraph 7 says, lawyers for the petitioner also applied for leave to serve interrogatories on the first respondent. The court dismissed the application, and an application for review of the said decision is currently pending. Should the court allow any interrogatories to be served, responses provided may also be relevant evidence which may require a further witness statement. And so the point that he was making with regards to paragraph 6 and 7 was to say that, look, it's completely out of place in that it's not admissible because it was not part of the pleadings. He again adds that the individual who is in the box testifying has not claimed to be someone who is a representative of the individual who filed this particular petition. He is simply coming in as a witness, and so he may not necessarily be aware of the processes that have been initiated by the petitioner in this particular matter, i.e., it is the petitioner whose lawyers have filed to ask for the EC to admit to certain facts. It is their lawyers who are at the time seeking a review of the interrogatories ruling. And so you as a witness, you are coming to testify to matters that are in your knowledge. And you heard Mr. Chikata in his response make the point that, look, Mr. Asiedu Nketia is capable and will be able to handle whatever questions that you ask related to the processes that have been filed so far. And so that was the direct response with regards to paragraph 6 and 7. He then goes on to paragraph 25. And paragraph 25 of Mr. Asiedu Nketia's statement reads that this was clearly contrary to the responsibilities the chairperson of the first respondent and the first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that administrative bodies which provides that administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. In fact, the ever-changing figures put out in the unsigned press releases and what was posted on the website of the first respondent in respect of the declaration of the presidential election betray the determination on the part of Mrs. Jean Adukwe Mensah. And so the argument that Mr. Koto-Ampao made with regards to this particular point is to say that this was also not pleaded in terms of the petition.
All right. So Joseph, court has gone on recess. Do we know when they would return?
As we speak, we do not know exactly when the court will be coming back, but we understand that it's a process that may take a bit of time because per my own count, and you realize that there were a bit of a disagreement about how many the paragraphs that were being attacked. I personally counted about 9 of them, and so there are 9 different issues that the courts were going to look at. And if you heard Mr. Chikata, the point that Mr. Chikata made was to the effect that ordinarily, if they were going by the previous rules where you have the witness go into the box and lead evidence and testify one after the other, you would have realized that the question would have been asked at which stage, if Mr. Asiedu Nketia is answering the question, you would have the opportunity to raise that objection. So it would have meant that the objection would have been taken one after the other. But because the witness statement is in whole, you have at least 9 specific objections that were raised. And so the court will be taking each of these objections and will be reading each of these particular paragraphs to come to a certain conclusion. The conclusion will be, 1, are these matters that, as has been argued, were pleaded in the petition itself, or are these matters that have been adequately pleaded such that we should permit it to be admissible in this particular matter? And so it will be quite a process that will be going through, taking those objections and those statements one after the other. And so because of that, we understand that it may take a bit of time, but as we have seen the judges exhibit and done over the period of this particular petition and in their own utterances to make the point that they are determined to ensure the expeditious hearing of this case. And so the expectation is that this should be resolved in a quick manner to enable the trial to continue.
Let's talk about the mood in that court leading to the point where the justices had to take a break.
It's more of at the initial stages there was a lot of silence and people were listening, and in between at a particular point you could sense a bit of frustration from the side of the president's legal team. In fact, it manifested in open court when you heard Mr. Koto-Ampao stand up to say that the petitioner's lawyer had been going on and on about the same point for about 20 minutes. It was because many had felt that, look, when the whole thing started with regards to today, you had Mr. Koto-Ampao who spoke for just a little over 7-8 minutes towards 10, but under 15 minutes essentially. You had Mr. Justin Amenuvo, who is representing the first respondent, the Electoral Commission, who also spoke quite briefly. Then you have Mr. Chikata, who spoke for well over 35 minutes and responding to those objections. So at a point, it was a bit of a process that had taken a bit too long, and that's how come you had the second respondent's lawyer coming to make that particular interjection. But in terms of the mood entirely, it was that of silence and listening, and at those material moments when those objections were verbally made to the court, you could get a sense that people felt that the process had taken a bit too long than it ought to have taken. But the judges obviously allowed and were of the view that Mr. Chikata should be allowed to speak to the issues, and so he continued with his presentation, and that lasted for quite a while. Immediately, the judges went on recess. A lot of people left the courtroom, and trust me, Mavi, a lot of them headed towards the washroom. Others took walks to stretch their legs because it's a process that we are sitting and listening, and some are taking notes, and you don't have the opportunity to stretch your legs. And so in between myself, I even came out at least 2 or 3 occasions to stretch my legs as well because it was quite a process.
Apart from Johnson Asiedu Nketia, would we see any other witnesses mount the box at least before the end of today's session?
It's very difficult to tell because Mr. Asiedu Nketia's process has actually not even commenced yet. Once he declare with this objection, it will mean that a cross-examination will take place, and he'll be cross-examined by lawyers for the first respondent, that is the Electoral Commission. Then lawyers for President Akufo-Addo will also take their turn. And so it's already lunchtime now. We don't know how long the justices intend to hold proceedings today. From what we've seen in the past, they don't go beyond the 1:30, latest 2 p.m. And so we do not know whether today will be an exceptional circumstance where they will opt to sit for quite a while. And so that is an issue that we look forward to. But in terms of what has been filed, Dr. Michael Kpesa-White is the other witness who is supposed to testify at the Supreme Court. And he, you recall, was one of President Mahama's representatives at the Electoral Commission's National Coalition Center. That is what we popularly call the strong room. And he has also filed witness statements as well. And so it all depends on how soon they're able to deal with this particular aspect of it.
And Joseph, before you go, the Chief Justice obviously been busy with this matter, but he's also concerned about decongestion in the courts because of COVID-19. And so we're told that only parties related to a particular case will be allowed entry into the courts. Has that happened in this matter of the election petition?
So what is happening in terms of those who are allowed into the courtroom is that there's a bit of a limit. And so what takes place is that the accreditations have been issued, one for journalists. Accreditation have also been issued for the respondents in the case. And so the Electoral Commission team, those who are coming over, they are also given some of the documents. Then aside from that too, accreditation are also given to President Akufo-Addo's side. And so a certain number is given to them in a manner that ensures that no one sits close to the other in the courtroom. And so there's a space in between, and that is what is actually being done. And so that is by way of how it has been limited. And so it actually means that if you don't have any business in this particular proceedings, be it you are not a part of the delegation of the first respondent, you are not part of the delegation of the second respondent, you are not part of the delegation of the petitioner, when you just wake up from home and you walk, you will not even be allowed onto the compound itself. Because on the compound here, there are canopies here where pressmen and those who have come in here who are part of the delegation may not be necessarily able to enter, are also equally given accreditation that entitles them to the compound here. And so that is how the process is being managed. And so if you wake up in the morning and you are at home and you feel that because you think that there is a major case going on and you want to come and witness proceedings, you are not going to be allowed on the compound or even into the courtroom itself because of that particular process. And so that is by way of the measure. And in terms of the sitting arrangements, the spacing is done. In terms of how we, even as pressmen, sit at the gallery, our seats are actually numbered. And so if you look at my accreditation, for instance, it is actually numbered. It has a specific number indicated on it, and so it's a specific seat in the courtroom that has that particular number on it. And so every time I go into the courtroom, I sit in that exact seat, and next to me no one sits. It's an empty seat that has a paper placed in it that is stapled on it with the inscription, "Do not sit there," to ensure that there's enough spacing. Also, before you get into the courtroom, there are people there who provide a sanitizer, aside from the Veronica buckets that are at the entrance of the courtroom as well. And so that is by way of the COVID-19 protocols and that particular release that came from the Judicial Service, signed by the Chief Justice for that matter.
Joseph, you've been working really hard. As the justices have taken a break, we'll allow you to also take a break and grab something. We'll definitely return to you. Joseph Akablaze, our court correspondent, following closely this case at the Supreme Court. Kojayang Singh has been here with me. We've been listening and watching, and at times, you know, getting a bit confused with all the legal jargons and what's happening in the court. What have you captured?
There's a lot flying over our heads, but there's a lot that we're also understanding, because that's the nature of these petitions. When they are televised in this manner, you can tell that the actors involved are aware that there is an audience that is not, that are not insiders into their daily work, and so they take the time to explain certain terms and so forth as they go along. I've noticed Chachu Chikata does that. So does the lawyer for the second respondent, the president, Mr. Akoto Ampao. The judges do it on numerous occasions. So I picked up quite clearly that there are three reasons why the second respondents are objecting to Mr. Asiedu Nketia's witness statement. The three reasons are that some of the things he said, well, they don't reflect the original plea of the applicant. The second reason is that they feel some of the things that have been said in this witness statement are prejudicial. And finally, they believe that some of the statements will scandalize the court. And we've seen the court take on this objection in a certain manner, besides the responses that the applicant has made to the objection. So the applicant, in this case, former President Mahama and his lawyer, Chachi Chikata, have made certain responses to the objections. They are insisting that the statement should be accepted because, indeed, the plea was not supposed to outline every detail. And that's why there are witnesses, to bring information that will then build up to their plea. So if there is something in the statement that is not reflected in the plea, that's because the plea is brief. And then, of course, they've talked about whether or not some of these issues are scandalous to the court. The court itself sought to rectify that particular objection by saying, look, we are the court, and we've read the statement. If there was something in there that would scandalize the court, should that objection not come from us, or should that reaction not come from us? So we've learned a lot. It's been a fascinating morning. And I've been making a certain note about something. From the beginning, we've been quite concerned, let's put it this way, we've been waiting to see how the court intends to stick to its timeline, which has been set out by the Judicial Service Manual, which describes the method by which an election petition should be carried out. We've all been wondering how the court is going to stick to its timeline, and the more we watch this, and the more the processes unfold, well, the more intrigued I am about how the court is going to do it. Because some of these processes can really stretch out a day. I mean, look at this. We have not heard one word of testimony from Mr. Asiedu Nketia yet, because we're dealing with some hefty objections. So how will this unfold? How many witnesses will each side call? And how many objections will there be? And how will these objections be dealt with? You now start to wonder how the Supreme Court feels about its original ruling, on some of the things that might have saved time in the process. Whether they feel any way different about those rulings, we don't know. But we're certainly observing something that could end up being a lengthy process.
Well, this is what the lawyers say, that I put it to you, dragging the entire process. And I guess we're beginning to have a feel of it just on day one, the beginning of the trial, the trial itself, even though it was supposed to begin today. That is what we're supposed to be witnessing, except that we haven't heard anything at all from the witness. We've been listening to the lawyers, make a case to strike out some paragraphs in that witness statement, and the lawyer on the other side, Chachi Chikata, also defending the portions strongly in that. This has been rather unusual, some lawyers will tell you, because usually this would not happen in a normal court. But of course, the Supreme Court is the ultimate court, and so they tend to do things differently. And an election petition, obviously, is also very different, not the normal kind of court issue. I read Justice Databe's book on reflections on the Supreme Court as he exited the court, and he was talking about how proceedings such as what we're witnessing in the 2012 elections, when it is broadcast and people follow it, it also helps them appreciate the work of the courts, and it demystifies. People have all sorts of things that they think about how the court operates. So this is certainly a good thing. But the fact that we're having to sit and wait and witness all these arguments, it also gets quite boring, I guess, for some people who may not really understand what's going on.
You can well imagine that not everybody is enamored with legal, conversations and legal arguments and what happens in court, especially if you've never had any reason to go to court for anything personal. It's a difficult thing to connect to on a personal level, unless you have an interest in the matter. But the thing that matters to all of us is that these are necessary proceedings of our democracy. We say we live in a democracy. This is the cost of it. This is what it actually means, that everybody gets their day. Everybody gets the opportunity to make their case. And observing how that case is made, observing how that case is handled, observing how that case is judged, all of it opens our eyes more and more to the nature of our democracy. And in fact, it grows our democracy. I spoke to a Supreme Court judge who was a member of the committee that put together the guidelines for the guidelines that the Judicial Service put out on how an election petition should be run. And I remember very clearly how he talked to me about how these are uncharted waters that they are having to rationalize. They are having to bring logic to something that they haven't yet experienced. Okay, because you can never predict what one side or the other is going to say or do or object to and how that will affect the process. You have to deal with it as it comes. And these are some of the smartest people in the land, sitting on this bench, presiding over this particular petition. And they are having to draw on all of their experience to deal with the matters in a way that actually moves things forward, and without sacrificing justice. It's a very, very tight rope that they are walking. But we are all observing this, and even though it might seem a bit snore-inducing, it's important that at least the gist of it is understood and appreciated by all Ghanaians, because this affects us all.
Absolutely. That's why we're watching. That's why this is out there for everybody to follow. Just to remind you, the issues for determination. We know that broadly Mr. Mahama disagrees with the declaration of Mr. Akufo-Addo as president-elect then, after the 2020 presidential elections. But for the court, these are the 5 issues tabled for determination. 1 is whether or not the petition discloses any cause of action, that is, if there is any legal grounds for the petition. There's also the issue of whether or not the second respondent, in this case, Nana Addo Dankwa Akufo-Addo, met the Article 63(3) threshold of the 1992 Constitution. This constitutional provision states that a presidential candidate must obtain more than 50% of the total valid votes cast to be declared as president-elect. The third issue is whether or not the second respondent, again, Nana Addo Dankwa Akufo-Addo, still met the Article 63(3) of the 1992 threshold by the exclusion or inclusion of the Teshiman South constituency presidential election result. The rest, whether or not the declaration by the first respondent, the Electoral Commission, on December 9 of the presidential election conducted on December 7 was in violation of Article 63(3) of the 1992 Constitution, and whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election result of 2020. So after all is said and done, we would find answers to these issues that have been raised. Our update here on Joy News is in association with Petrosol DBS Roofing and Core Mixture. Due to hard times, we have become value hunters. But are we hunting for value the right way? Remember, your engine is more valuable than just cheap fuel. Be smart, hunt for holistic value. Holistic value is when you have quality fuel at the right quantity and at a fair price. At Petrosol, we serve clean fuel in full quantity at a fair price, and that is holistic value. So come to us. Petrosol, clean fuel in full quantity. And after several years of intensive research, DBS Industries Limited brings you roofing sheets to help complete your dream house in style. Experience the amazing touch of ColorLink Plus roofing sheets in 26 years, which means ColorLink Plus roofing sheets always stay clean and beautiful for you. And there's more. We're giving you a whopping 20 years warranty against fading and peeling. Visit DBS Industries Limited here in Accra on the Spintex Road. in the DBS building near Papaya Restaurant, or you can call their hotlines on these numbers 024 084 4444 or 054 3286 637, or visit their factories in Kumasi, Tamale, and Takrady. DBS Industries Limited, we truly are your roof expert. Stay with our coverage. When we come back, we will be showing you what you missed. You'll be watching and listening to what you missed since 10 a.m. when the court sat.
Petitioner. Laws. Jane Mensah is representing the first chairperson, representing the first respondent. Peter McMahon, my laws, is representing the second respondent.
Having difficulties hearing you.
If your lordships please appear for the petitioner with my learned friend Tony Lither. Okay.
May it please my lords, Justin Amenuvo appears for the first respondent, with me, A.A. Somoa Asamoah.
If it pleases your lordships, Akoto Ampao appears for the second respondent. My lords, with me are my colleagues Frank Davis, Kweku Esirifi, and Yao Pong.
My lords, our first witness is ready. We have indicated that depending on the response to the request to admit facts, there may be a supplementary statement from him. I don't know whether your lordships want us to make a formal application for that supplementary statement, or whether based on our indication in the statement, in the witness statement that is filed, once we confirm the status of the request to admit facts, that will be taken as granted, because, I mean, I just want to be clear so we are guided appropriately. I'm sorry?
We want to take the witness first.
Very well.
Bible.
I
I, Johnson Asiedu Nketia,
do in the name of Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give
that the evidence I shall give
in this case
shall
be the truth,
the whole truth,
and nothing but the truth.
and nothing but the
So help
truth.
me God. So help me God. S-O-D in English.
Name of the Almighty God swear
That the evidence I shall give in this case shall be the truth, the whole truth,
and
nothing but the truth.
and nothing but the
So help
truth.
me God.
So help me God.
I lost S-O-D in English.
My lords, I believe the procedure, since it's not expressly provided in CI 99, I believe the procedure is as provided in CI 47 in respect of witness statements being. I just needed to be clear, maybe. So we're getting a copy of the file copy of the witness statement. Yes, so that we can, what we have filed. I'm sorry.
We adapt it as his evidence in chief, and then cross-examination will follow.
Yes.
Just so that we are not caught by time, we have objections to certain parts of the witness statement, and we would apply to the court to have those parts struck out as not relevant nor based on the pleadings of the petitioner, or otherwise scandalous and prejudices unfairly.
Mr. Kotuampa, the witness is here to identify the witness statement. So just wait.
No, I'm just serving the court with notice, because it is sometimes assumed that if you keep quiet and you tender it in, then you are caught.
Mr. Kotuampa, we don't tender evidence. So when it comes to the box and he relies on it, after he has been sworn, he relies on it, then it becomes evidence. Then if you have any objection, you can raise it. Yes. As it is now, it is not evidence before us.
Please give your full name to the court.
I'm Johnson Asiedu Nketia.
And you have filed a witness statement on behalf of the petitioner.
Yes, my lord.
Can you identify what the Deputy Registrar has made available to you and confirm that it is the witness statement that you have filed?
Yes, my lord. This is a witness statement that I have filed.
My lord, we wish to tender that witness statement, or it's adopted by the, yeah, very well, very well. That's the procedure.
Yes, my lords, as I've said, we are objecting to certain paragraphs or parts of some of the paragraphs in the witness statement of Mr. Johnson Asiedu Nketia on the ground one, that they are not based on the pleadings. 2, they tend to unduly prejudice some of the parties to this suit and are scandalous, and accordingly we would pray that those paragraphs or parts of those paragraphs be struck out as such. Yes.
The grounds of objection. The first one was that it was not based on the pleadings.
Yes.
And the second one, unduly prejudicial and scandalous. Yes. Yes. What is the third one? The third ground.
Is it scandalous?
Yes.
Oh, okay.
My lords, I believe that it's well established that a party's evidence.
But could you identify the paragraphs first?
Very well, very well. My lords, we are referring to paragraphs 21, I have it. Yes, Valerie.
You have set out 3 grounds. Which of those 3 grounds is applicable to paragraph 21? What I'm asking you to do is tell us your ground of objection within the 3 before you start your argument, so we can follow you.
Hold on. My lady, paragraph my lady, paragraph 21 is not pleaded. There's nothing in the pleadings to that effect. Yes. The pleadings, this evidence that they are seeking to lead is not borne out by the pleadings, my lady.
It's not based on.
It's not based on.
Okay.
My lords, we also object to.
Do you mean the reference to the website in that paragraph?
It says moving and changing and subsequently deleted. These are very material facts. If they sought to rely upon it, they should have pleaded it. My lords, we also wish to take objection to paragraphs 6 and 7 as completely out of place. Out of place in the evidence in chief.
What does that mean? What does being out of place?
It's not admissible, my lord, because it's not admissible because it was not part of their pleadings. Their lawyer may raise that matter before the court in address, that this cannot be part of their evidence.
Paragraph 7 or
6 and 7.
My lords, we also take objection to that portion of paragraph 25, which starts on page 6 of their witness statement. Thus, the first respondent, in respect of the declaration of presidential election, betrayed the determination on the part of Mrs. Jean Adukwe Mensah as returning officer for the presidential election, and certain officials of first respondent to have second respondent installed as president of Ghana by hook or crook. My lords, we think that this is highly prejudicial and scandalous. There's no pleading that can support this type of scandalous and prejudicial piece of evidence, and we pray that it is struck out on those grounds. My Lord.
Yes, so we are clear. Is it the sentence starting from page 5? In fact, yes. So it starts from page 5.
Yes, you are right.
Ends at
page 2. Yes, it starts from page 5. Relax. Writing. My lords, our next objection relates to paragraph 26 from the sentence that reads, the chairperson of first respondent, Mrs. Jane Adukwe Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018, and with whose wife, Ms. Jean Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was thus at all material times in the conduct of her responsibilities biased by prejudice in favor of the second respondent and against the petitioner. My lords, we pray that this part of paragraph 26 be expunged as scandalous, prejudicial, and not based on the pleadings. These are very serious material allegations of fact, and they were not pleaded. Well, the next
We thank you for staying with us. We return to the Supreme Court to join the 7-member panel hearing the 2020 election petition filed by John Dramani Mahama.
The first and second respondents have raised objections to parts of the witness statement of Mr. Johnson Asiedu Nketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6. The first and second respondents have raised objections to parts of the witness statement of Mr. Asiedu Nketia, who has been sworn in as PW1. The objections to those paragraphs, precisely paragraphs 21, 6, 7, 25, 26, 28, 30 and 32, 33, and 37. Both counsel based their objections to the paragraphs in the witness statement of PW1 on two grounds. A, that some of the paragraphs under attack are not based on the pleadings on record. B, some of the statements are unduly scandalous and prejudicial. It would be preferable to set out the paragraphs in the witness statement which in our view are amenable to be struck out from the witness statement. We have the opinion that paragraphs 6 and 7 ought to be struck out as the witness, Mr. Asiedu Nketia, cannot testify on the facts in the said paragraph. It would have been admissible if the petitioner is himself testifying. The statements in the said paragraphs are not within the knowledge of the witness. We find paragraph 21 as a matter which has its foundation in the pleadings and same is accordingly maintained. As regards paragraph 25, we found that part that is the sentence beginning with, quote, in fact, the ever-changing figures, end of quote, to the end of that paragraph is hereby struck out as not based on the pleadings. In respect of paragraph 26, the court is of the opinion that the statement from line 5 above, beginning with, quote, the chairperson of the first respondent, end of quote, to the end of the paragraph is struck out on the basis that it has no foundation in the pleadings. As regards paragraph 28, from line 6, that is the sentence beginning from, quote, the secrecy and the lack of transparency to the end of quote, to the end is not borne out of the pleadings, and we accordingly struck it out. In respect of paragraph 30, the court is of the view that it has no foundation in the pleadings, as it just refers to CI 127, which the witness cannot testify on the statute. As regards paragraph 32 and 33, we found that they are based on the pleadings and therefore ought to be part of the witness statement, and they are accordingly maintained. In respect of paragraph 37 of the witness statement, we found that it is just an inference to be drawn and not evidence. We therefore proceed to strike it out. The court therefore orders the paragraphs referred to as offending the law are hereby expunged from the witness statement of PW1.
And Lords, we are most grateful.
We are most grateful to the court.
As the court pleases, and just for the sake of clarity, I would like to understand what was said in respect of paragraph 30. Paragraph 30, because the reference to the regulations in CI 127, that's in the first sentence, but the rest of the paragraph, including the exhibit C, is not related.
Yeah, the whole of paragraph 30.
The whole is in,
yeah, it's
the whole of
yes.
That's the whole of paragraph 30.
Now, the 2020 December 7 elections was conducted under rules passed by Parliament. Is that correct? The 2020 December 7 elections were conducted by rules passed by Parliament. Is that correct?
That's correct, my lord. It is supposed to be conducted by the rules, but we have issues about the application of the rules in the conduct of the elections.
CI 127 is binding on the petition. That's well, yes, it was 6 pounds, sorry. The petitioner appointed agents for each of the polling stations in the country, is that correct?
That's correct, my lord.
How many agents did the petitioner appoint for each polling station?
2 agents.
Now, at each polling station, the petitioner and indeed all the other candidates had agents, is that correct?
I cannot speak for all other candidates.
Now, you trained your agents on what their duties at the polling stations would be.
Yes, my lord, that's correct.
You trained your agents on how Forms 8A and 8B was to be completed in each of the polling stations.
That's correct, my lord.
You trained your agents on how each form was self-auditing and designed to reduce errors and mistakes. Is that correct?
That's correct, my lord.
You also trained them that at any point that they had a problem with what was happening at the polling station, they could refuse to sign the form but state the reasons for it. Is that correct?
That's correct, my lord.
You also trained them that if they stated the reasons for not signing, the issue will be taken up at the constituency coalition centers. Is that correct?
That's correct, my lord.
You also trained your agents that at the end of counting and entering of figures, they collect their copies of the Form 8, whether or not they signed it. Is that correct?
That's correct, my lord.
You also appointed agents for each of the 275 constituency coalition centers. Is that correct?
That's correct, my lord.
You trained them that unresolved issues from polling stations will be noted on Form 8B for resolution at the constituency coalition centers. Is that correct?
That's correct, my lord.
You also trained them to expect to receive the duplicates of the Form 8Bs that have been given to them at the polling stations. Is that correct?
That's correct, my lord.
Now, you also train them to cross-check their Form 8Bs with anything that is done at the constituency coalition center. Is that correct?
That's correct, my lord.
You also train them that from all the information on Form 8B, the EC officials will collate the results onto Form 9. Is that correct?
That's correct, my lord.
You train them that after collating on Form 9, the results will be entered on Form 10. Is that correct?
That's correct, my lord. But all with the involvement of our agents.
Now, you also trained them that if they had any issues with Form 10, they could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Now, you also trained them that once the Form 10s were completed, they were entitled to their copies.
That's correct, my lord.
So it is right to assume that your agents had all the Form 10s with them. Is that correct?
Come again, my lord.
I'm saying that it is right to assume that based on your answers, your agents had the Form 10s with them.
Yes, my lord, it could be assumed.
Yes.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together, and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Okay. Yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known. But that is not the declaration of the presidential election.
Okay, good. You trained your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated into Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somewhere only to be invited to sign. They are involved in the collation, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional coalition forms, your agents signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agents signed, it was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct?
Bono
East.
Bono East. Bono.
It was signed by Ali Muhammad Samsudin.
That's correct, my lord.
Good. Now, on each of those forms, your agent signed to declare as follows. Quote, we the undersigned do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Collation Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the collation. Is that correct?
That's correct.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right, right. Now, are you aware that at the National Collation Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent will be present in court to testify as to what happened in the National Collation Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, my lord.
Dated 9 December 2012. I suggest to you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot say it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in 2 parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D.
Yeah.
Would you be kind enough to tell the court the person who signed this letter?
My Lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my Lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Dimfi. Do you know him?
Yes, my Lord.
And I'm further putting it to you that Ashanti was signed by, was certified by Mr. Rojo Metonunu.
My Lord, the agents who come subsequently will be able to confirm that or deny it.
Do you know whether Rojo signed or not?
Please, I would like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Broja Dimfi, Rojo Metonunu signed against it. Do you know or you don't know?
My Lord, the documents that come to our notice is the final declarations, the signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Broja Dimfi in Ashanti region, and
yes,
when it was transmitted,
I can testify.
And when it was transmitted to the strong room, as you call it, Mr. Rojo Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the eastern region. Is that correct?
That's correct, my Lord.
On the first sheet, your agent signed the form. Is that correct?
My Lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one. The one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my Lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My Lord, I have realized that the totals there are. Yes, I've looked at. Yes, my Lord, that is precisely what I'm about to do. I have done the collations, the additions, and I've realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
No, we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1196751 and not the 1236940 that was written on it.
My Lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My Lord, my Lord, we brought the calculator.
Yes.
If the court will permit, you can do that.
Yes.
Order in court, please. Order.
1, 4, 6. Services. No. Appears your calculator is not 1, 2, 9.
Is order in court.
Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1236940. What will you arrive at?
One, two, 40,109.
40,000.
109.
189.
189. Sorry.
It is 189. Yeah. Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence. listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I am putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, that's making extra gains to make the total valid votes 1, 2, 3, 6, 9, 40. I am putting it to you.
My lord, can you come again?
I am putting it to you that when Ayenswano results that I have just shown you, that if you take the difference that you got from the first sheet from what they had written, you get 4189, and that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 940. And I'm putting that to you.
Yes, my lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem for which you ought to have written to the first respondent.
I deny that, my lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My lord, I repeat that if the figures are in contention, it is difficult to determine who won.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
Yes, my lord. Well, my lord. Well, my lord.
In the presidential elections, regions are not won.
there is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections take place anywhere else.
Right. Well, I am putting it to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Rojo Metonunu in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the averments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court.
Paragraph 12. Yeah, I'm ready.
Paragraph 12 of the amended petition. Sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 13,121,101. A figure that is completely missing from the purported declaration. 111. A figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020, and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid votes, total valid votes, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th, as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, You have stated that your agents, Mr. Metununu and Dr. Pesa White, left the strong room. Is that correct?
That's correct, my lord.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report an exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
My lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, they would have seen that those figures, 13, 121, 111, was the total valid votes as captured on Form 13.
My lord, I can't respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting it to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My lord, I have indicated that the processes within that National Coalition Center are not within my personal knowledge, and so I cannot answer, I cannot admit or deny.
Now, at the time the petitioner filed this petition, he knew the results from the Techiman South constituency, not so?
My lord, I'm not the petitioner.
Okay, we'll leave it. We'll address it.
Now, let me refer you to your form, your Exhibit E. Look under Bunu East. Bunu East.
Yeah.
Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not our figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence? I'm putting it to you.
Well, there's nowhere in the evidence that you propose to say that the petitioner got all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court.
My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenuwo, please.
Yes.
Reframe the question.
Now, yes, my lords.
He's raised an objection. What is your response to that? You are reframing the question.
Lords, I'll rephrase the question.
Okay.
Right.
And then tell me that.
Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner had obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time
you were
filing the witness statement?
Yes.
Yes.
They were known?
Yes.
Good. I'm further putting it to you, therefore, that as at the time that the petitioner filed the petition, all the total valid votes in Techiman South were known.
On behalf of the petitioner.
So I am putting it to you.